Passover case from supplementary list item 7 contains in 158 of 2025.
Issue appears to be the same, so Lordship, the common order was passed. Lordship versus. Maybe in the next page, Lordship, the same order will be passed in this matter also.
Common order was passed.
Same issue in that matter also. Lordship.
Same issue, maybe.
Yes.
But
I
for
beg your
separate
pardon.
cases.
In the next Friday, Lordship, next
Who is
Friday.
there?
She is the deputy director, Lordship. Director is in the conference in the New Delhi, Lordship. She is unable to join. So only the humble request for next Friday, Lordship. As the last.
Yes, madam.
Unmute.
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 Unmute yourself, please. Madam, you please unmute yourself. I can't hear you.
Unmute.
The reason order.
Sorry, kindly repeat.
Ma'am, in this case also, we will pass the reason order. Actually, in another similar matter, we had passed the reason order. But as per court's order, we will pass, honorable court's order, we will pass the reason order in this case also.
That's okay.
Yes,
Every case is a distinct case. You have to pass separate orders for all the cases.
Okay.
Correct?
Correct. Yes.
Continue civil 158 of
Yes.
2025. The deputy director. Are you the deputy director?
Yes.
The deputy director. Higher education. State of Jharkhand has joined the proceedings online. The counsel for the opposite party is also present. It has been submitted that as per the show cause, reasoned order in connection with another case has been filed, which was of similar nature. However, it has been submitted that a separate reasoned order, so far as the present case is concerned, will also be shortly passed. In terms of the order dated 18/3/2024, passed in WPS number 2381 of 2023. Was there any provision for hearing?
Decided presentation only.
Just a minute.
Operative person. To file that presentation, to pass the agenda.
That's right. At the request of the opposite party, the matter is adjourned and is directed to be posted on 13th of June.
Yes, sir.
Is that okay, madam? Okay.
Yes, ma'am. Yes, ma'am.
Supplementary
Yes,
show
ma'am.
cause be filed by 11th.
Thank you, ma'am. Thank you.
Passover case from Delhi list item 70 WPS 2/3 of 2018.
Yes, Mr. Sani.
In this case, not
Which award have you annexed?
no. Your Lordship, just see for a moment. The supplementary petition I have filed now.
Yes.
Wherein there are two references. Earlier to the reference out of which the writ petition has been decided, and the LPA was decided. Earlier to it, there was an award. If your Lordship may kindly see, that is award dated 24/26/1987 in reference case number 76 of 1985, page 5 of the supplementary petition. Then it was affirmed by annexer 11, that is 21/3/1988 in CWS number 215 of 1988. Now, what is the link between the two? Your Lordship may kindly have a look of annexer 7, the judgment of the writ petition under the second round litigation, annexer 7, page 24. I will just place note the relevant partner. Your Lordship may kindly see for a moment. In this writ petition, the award was reference case number 50/91. Annexer 7, page 24.
Yes, 50
First
by
paragraph.
90. Yes.
Reference, that is, Milord. Now, your Lordship, just see for a moment, Milord, the paragraph 8 of the said judgment.
Yes. Yes, please.
paragraph 7 towards me. Paragraph 7, then paragraph 2. You see, may kindly see. It is an admitted case that the concerned workmen were the casual wagon loaders of Rajhara Colliery. Loading of coal in wagons, trucks by the contract laborers in the prohibited category. All the concerned workmen were working under the contract.
I'm not concerned with that. Your
I'm
reference case was reference case number 50 of 90.
91.
Where is that award?
Yes, that award will not be not on record.
So,
But you also just see the
similar case से नहीं होगा.
similar. I was a the workman. I have given you
No, I'm looking for reference case number 50 of 90.
50 of 1991.
Where is that?
You also may kindly see one of the earlier two, it not annexed 10, page 5, which I was referring to, page 5 of the supplementary affidavit. Whether the demand of United Coal Workers Union.
No, we are not. You see, there is a specific reference to a particular reference.
Yes, I mean, the first is I'm just coming and my name is not at page.
We are not bothered about it. What is it?
I was
So
also
do you
one,
want to say
and
that
this has a nexus.
No, do you want to say that this reference case number 50 of 91 does not exist?
No, I don't say so. It was a reference case note. It was subsequent to the earlier reference, and why it has come, that I will just examine. You'll also just see what
If reference case number 50 of 91 has any relevance in this case, you have to file the award in that
yes,
case.
I should. Otherwise, I cannot explain what is the nexus between the two. I have to file because I have filed the only the judgment
case
of the
number
report.
233 of 2018. It has been pointed out by the learned counsel appearing on behalf of the respondents that the order passed by this court dated 21/3/2025 has not been. That was a preemptive order.
That I have already complied.
No,
If
but
the order
award-
was not that I was asked to show the date of birth of the workman concerned. Number one. Number two, my Lord, your Lordship just see why I was referring to paragraph 3 of the appellate court judgment.
preemptive order से बचने के लिए कुछ भी चाहिए.
कुछ भी नहीं फाइल किया जो नेक्सस है. I am not, your Lordship, just I wrongly referring to the single judge order. Your honorable division bench taken note of this fact. Page 29 हो चुका है.
अच्छा कोई बात.
Yes, there is no confusion at all. उसमें reference.
I also don't have any confusion at
Your
all.
Lordship just see the reference case is there.
I also don't have any confusion.
कॉपी रहता तो इसे लोग समय लगा दिए होते.
कोई बात. चलिए आप कल फाइल करिए इसको.
Yes.
चलिए the BPS number 233 of 2018.
And all these
The
facts have
learned
been
counsel for the petitioner is directed to seek instructions and file a copy of the award passed in
51
reference case number 50 of 1991 by the presiding officer, Central Government Industrial Tribunal number 1, Dhanbad. How much time do you need?
After vacation रख दिया जाए speech.
By 13th of June.
15th of June. So we have to
By
obtain the certificate.
20th of June. Great.
But only for 1 minute. If you Lordship see page 29. In the appellate court judgment, the LPA judgment
आपकी
refers
बात
this.
सही है लेकिन आप इस अवार्ड को प्रोड्यूस करिए उसके लिए.
अब मेरे पास नहीं होता
Certificate
तो
कब?
दे दिए.
Preemptive. Post on 26.
Online. जब वो इम्प्लीमेंट नहीं हुआ तो फिर दूसरा रेफरेंस हुआ. उसमें सब लोगों को कर दिए 111 को छोड़. 111 का भी बाद में हो गया जो लोग मेडिकली फिट थे. इनका 2011 की बात है. उसमें 2013 में
ले आइए अगर आपका
हम
होना है
लगा
तो वही है.
this is a fact and that is been noted in the LPA judgment.
We'll see.
Item 23, Civil Review 24 of 2025.
This is review.
Yes.
Why review?
Lord, review of order that 14/11/2024, by which your lordship has directed to get the tenanted shop by the petitioner's lord and.
You are the lead petitioner. Are you the lead petitioner?
Yes, Lord. And further direction was that the private respondent shall make a construction within a year, and thereafter they will allot the tenanted shop to the petitioners after giving security amount at the prevalent rent of that at that very time. But we got one thing, it had been not brought on the record that the petitioners had given security money to the respondents' fathers. The deceased respondent number 6.
आपका सिक्योरिटी का कहानी हम इसमें कहाँ से लेते हैं?
But this fact has not been come on the record, my lord, because my lord, the supplementary this order has been.
That is not the ground for review, no?
No, my lord, because my lord,
Who was supposed to bring it on record?
Pardon, my lord?
Who was supposed to bring it on record?
Who was the?
If there is any security money or anything
Yes,
like that,
yes,
who was supposed to?
That should be at least there is some direction to adjust that amount,
No.
that security amount to the given by the petitioners, and more of that on the top of that, my lord. Now, during the pendency of this review application, my lord, one Sarwan Kumar has come before the has sent a notice to me, to all the petitioners, that he is the rightful owner of that premise.
We do not.
And
I have appeared for the Sarwan Kumar as I have filed an IA as an intervener to be
In this review application.
No, what is you just tell us which ground, which ground of review are you addressing? Which is the ground?
This is the ground, Lord, that this fact has.
ग्राउंड में ग्राउंड से दिखाइए कौन सा
Yes.
ग्राउंड नंबर बताइए
Yes.
ग्राउंड नंबर
But I have stated in paragraph 9,
पैरा 9 नहीं ग्राउंड्स में बताइए कौन सा रिव्यू which ground
Lords. Yes, ground number 4, your Lord, as page 20.
ground number yes
For that, the order dated 14/11/2022 reveals the matter of allocation of shop in new shopping complex to be constructed subject to the payment of rent and security money as per the prevailing market rate, but the said order did not find place due to non-instruction and non-disclosure of the fact that mother of the petitioner number 1, the father of petitioner number 5, and the petitioner number 2 to 4 himself had made payment of security money to the father of the respondent number 6A and 6A to 6C
this is something
at the
new
time
fact
of
you want
handing
to
over the
bring
possession of.
you want to bring on record some new fact
Yes, Lord.
and yes that is not a ground for review
Look,
You will bring a new
review
fact.
lie either some facts have not been placed before your lordship or some error record
no ऐसा तो नहीं होता है कि review will lie when some fact is new fact will be brought on record for review. If you have any money claim against a private respondent, you may take recourse as per law. इसके लिए as order तो क्यों हम review
the order passed by your lordship comes in the way of that.
No, it will not come.
That's why my
No,
prayer
no,
is
no.
that.
No, it will not come. If there is any money claim arising out of transactions between two private persons, why will this order come in then? You have respondent number 6, right?
Respondent number 6 has already died, Lord, and thereafter respondent number 6A to C.
They have
Now they are
substituted.
numbering respondent number 7, 8, and 9.
You see, the
Subsequent.
order was passed at your instance that the learned counsel for the petitioners on instruction submitted that the
My
petitioner
lord,
would
adjourn
require
this
4
matter
months.
from first half to second half, though, so that they may
For,
seek instruction.
4 months time to vacate the premises, and it may also be observed that the respondent landlord should take appropriate expedient step for construction of the shopping complex and shall cooperate such that the petitioner are ultimately allocated the shop. This order has been passed at your instance.
No, not my instance.
The
no.
learned आपका पढ़िए जरा आप उस केस में अपील हो रहे थे
No.
नहीं अभी
तो
आ
फिर
But I
नहीं,
already
not
stated
at
in
your
ground
instance
number 4
मतलब क्या
में.
आपको मालूम है उस दिन क्या हुआ
ग्राउंड नंबर 4 में हमने लिखा है नॉन इंस्ट्रक्शन के चलते और इसलिए इंस्ट्रक्शन नहीं लिया जा सका कि 11/11/2014 को सप्लीमेंट्री एफिडेविट हैज बीन फाइल्ड बाय द रिस्पोंडेंट्स प्राइवेट रिस्पोंडेंट्स आज 14/11 को ये ऑर्डर हो गया तो इसमें जो है
ये जो पैरा नंबर 4 है
Yes.
इसको कैसे आप चैलेंज करेंगे
From the order you want.
of the order
order.
As per record, my lord, it is very clear that they have
Record?
they are
ये भी तो इट्स आल्सो
they are
पार्ट ऑफ द
gonna take-
रिकॉर्ड रोज आप लोग वर्बल सबमिशन करते हैं हम लोग रिकॉर्ड करके ऑर्डर करते
yes sir.
हैं अगर मान लीजिए सेम काउंसिल बोलते कि ये रॉन्ग रिकॉर्डिंग है ना तो हम सोचते क्या है दूसरा काउंसिल से आएंगे और बोलेंगे ये गलत है हमको इंस्ट्रक्शन नहीं था हमको मालूम नहीं था हम जानते नहीं थे इतना साल से ये ऑर्डर कब हुआ है दिस ऑर्डर हैज बीन पास्ड ऑन 14 नवंबर 24
Yes. 14th Amendment.
also
So that's why, my lord, they have stated that this review petition has been affidavit by the party, my lord. Therefore, my lord,
we are not on their instructions this order has been passed
one thing
now
also-
another council is coming and filing this review I will not accept
One thing also may also taken into consideration that, my lord.
आपको भी सोचना चाहिए नॉर्मली सेम ही काउंसिल रिव्यू पिटीशन फाइल है ना ये प्रोसीजर है ना
Yes. Lordship is correct, my lord, but they have come to me that
you,
that's why.
you should not be dancing to the tune of the litigants
Oh, but my lord,
नहीं should you be dancing to the tune of the litigants फिर वो तो कुछ भी बोलेंगे लिटिगेंट है ना कुछ भी बोलेंगे वो उनको हम कुछ नहीं बोल सकते
one thing also may kindly consider, my lord. Now, the my lord, during the pendency of the review petition, my lord, the one Sarvan Kumar has sent a notice to all of the
वो आप
petitioners.
उसको नोटिस में आपको जो करना आप करिए उसमें
Yes.
अगर टाइटल में डिस्प्यूट है कुछ तो they will go to civil court and settle their dispute.
I will not say anything
How that concern this writ petition?
any subsequent development which has taken place regarding any issuance of any notice by Shravan Kumar, you will have your remedy as per law. You can't do it.
They have sent,
That's why we have,
sent me.
I have appeared for passing of ladyship's order. We have come to know that they have come in the writ petition. Therefore, we are intervening in this
Review petition.
review petition.
देखिए सिविल रिव्यू नंबर 1 फाइलिंग नंबर डिफेक्टिव है क्या ये
Filing number शुरू हुआ।
पहले आप पढ़ गया है 24 of 2025.
24 of 2025.
the learned counsel for the petitioners has submitted that the review petition has been filed with respect to order dated 14th of November 2024 passed in WTC number 3550 of 2020. Primarily on the ground that certain security money was also paid by the writ petitioners,
Yes.
which does not find place, which does not find mention in WTC in the final order passed in the writ.
It was also not there in the writ petition.
The learned counsel has also submitted that one notice has been received by the petitioners by the intervener,
Yes.
We have given notice for the
issued by the intervener, who are claiming title over the property. The learned counsel for the respondent number.
5. Madhupur Nagar Parishad.
Respondent number 5, representing Madhupur Nagar Parishad, has submitted that the writ petition did not reveal any deposit of any security money, and if the petitioners have any money claim against against respondent number 6A to 6C,
Now in civil petition, the respondent number 7, 8, and 9.
who are in the writ petition, who are respondent number?
In review petition.
is 7, 8, 9.
7.
In this petition, they have added them as a 7 8.
789 nahi hai, 678.
Right. Because below
As respondent number
6 has already died.
7 and 8. Then the petitioner may take appropriate steps as may be permissible under law, but the same cannot be a ground for review. He has also submitted that so far as receipt of any notice by the writ petitioners, by any third party is concerned, the same also cannot be a ground for review of the order. The learned counsel has also submitted that, has also referred to paragraph 4 of the writ order to submit that the writ order itself was passed after the counsel of the petitioners who was appearing in the writ proceedings sought instructions from the petitioners, and the present review petition has been filed by a different counsel. After hearing the learned counsel for the parties and considering the point for review as argued by the learned counsel for the petitioner, this court is of the view that no ground for review of the order dated 14th of November 2024 in the PTC number 3.550 of 2020 has been made out. No error from the record has been pointed out by the learned counsel for the writ record has been pointed out by the learned counsel for the writ petitioner, so as to make out a case for review. The subsequent development which might have taken place at the instance of third party by itself cannot be a ground for review. Moreover, if the petitioners have any claim against the money claim against the private respondents in the writ petition, that is 6A to 6B, who are respondent number 6, 7 and 8 in the present proceedings, it is for the petitioners to take appropriate steps in that regard. The matters which were not placed on record in the writ petition cannot be a ground for review of the order passed in the writ.
Petition may
Accordingly, this review petition is dismissed. Are you seeking intervention? Since the review petition is being dismissed, there is no need for the intervener. Accordingly, petition seeking intervention is also dismissed.
departing the intervener to
आपको क्या
आपका
डिबेट?
कहा आपका रिव्यू आपको फुल लिबर्टी है,
Review हम
सिविल सूट
discuss
जाइए,
करिए, बाकी
इंजंक्शन लगवाइए,
आपको जो मर्जी हो करिए।
हो जाए।
All pending IAR.
नहीं।
नहीं है ना, एक
नहीं,
intervention pending है
एक intervention इनका
5902. I filed on 30th.
ये किस तारीख को?
Yes.
30
तारीख को file किया. 59.
कोई बात close.
Item 24 contains Civil 33 of 2025.
Sorry? Contains civil 33 of 25. Counsel for the petition for this order passed by this court has been complied, though belatedly. Counsel for the opposite party has submitted that the required papers has been filed. क्या किया आपको?
रीजनल ऑर्डर पास है, इनका प्रमोशन का रीजनल ऑर्डर हमने पास कर दिया, क्योंकि प्रमोशन असिस्टेंट प्रोफेसर में नहीं होता है, लाइन ऑफ प्रमोशन में नहीं आता, इसलिए इनको एमएससी
Considering the submissions of the parties, this court is not inclined to proceed any further in this contempt proceedings, which is hereby adjourned. If the petitioner is aggrieved by the reasoned order, it will be, he may take steps as may be permissible under the
Item 25 CRP 289 of 2025.
CRP number 289 of 2025. Learned counsel for the petitioner, Rajkishore Sahu seeks permission to withdraw this petition. Accordingly, this petition is dismissed as withdrawn. Any objection? Counsel for the state has no objection. देख लीजिएगा किस order से arise करता है.
Item 26 contains Civil 323 of 2025.
At the very outset, 6 weeks time to comply the order. As the continuous letter has been written to the petitioner to appear before the inquiry officer, he is not appearing till date. So in within a week, we will going to file a reason order, pass a reason order.
So I have not received any instruction regarding.
We have the copy of this.
What is the next date for appearance?
Next date, now they have written 4 letters to the petitioner to appear before. Now they are passing just because we made an extra payment to of the area of a salary. So there is an 1100 rupees extra has been made to the petitioner. So there is a direction to recover of the sum. But the concerned officer has sent to the report to the headquarters.
I'll take the Xerox of this letter from my friend. I'll complete it.
Just 2 weeks time we will pass a reason order regarding the same motion.
अभी तक पास नहीं किया है.
No, Your Lordship, just because we received this.
Opportunity of hearing the time. पूछ के बताइए किस दिन देते हैं. इस तरह से खेल मत करिए. Ask him. अभी तक नहीं किए है ना reasoned order.
No, Your Lordship.
एक दिन फिक्स कर देते हैं यहीं से. बताइए डेट बताइए. पूछ के बताइए कौन से दिन. अभी तो इंस्ट्रक्शन ले लिया. पूछ के बताइए किस दिन भेज सकते हैं. टाइम के साथ फिक्स कर दो.
Item 27 wrongly listed. Item 28 contains Civil 506 of 2025.
Praying for some time also that I able to so called this has come for the first time.
इस पर तो compliance report आ ही गया है.
इसमें इसका
इसमें तो कुछ
सिंगल मैटर में आता है।
similar matter में आ गया है ना. क्या किए इसको?
बहुत सारे लोग को अलाउ कर दिया गया है
हाँ
और इसका देखना पड़ेगा मैम कि सर क्या
और
स्टेटस
आप भी इंस्ट्रक्शन लेके इसमें शो कॉज फाइल
जी मैम इसमें एक चीज़ और है कि 10 में इसमें जो कम डिस्प्ले अथॉरिटी को डायरेक्शन दिया गया था उसको पार्टी नहीं बनाया गया मैम इसलिए
पार्टी नहीं बनाई
नहीं बनाया गया है उसको डायरेक्शन उसी को था 10 दिखाया जाए उसमें रिपोर्ट किए हैं ये पेस्ट है
पेज 10
हाँ पेज 10 second para. So far as the petitioner who are teacher of class 6 to 8 are concerned, the reason for pendency required scrutiny
कौन
was
सा पेज 10 नहीं समझ आ रहा आपका ख्याल कौन सा पेज 10 आपका कंटेंट पिटीशन
yes ma'am, based on the contempt petition.
हाँ पेज 10 रनिंग पेज 10
Yes,
अच्छा
ma'am.
ये वाला
हाँ
ठीक
second para my lord. So far as the petitioners who are teacher of the class 6 to 8 are concerned, the reason for pendency of the required
एडमिनिस्ट्रेटिव कम डिसिप्लिनरी
Yes, ma'am.
अथॉरिटी
Yes,
बस कौन है वो अथॉरिटी पूरा नाम बताइए
प्राधिकार
लिख के दीजिए Nobody appears on behalf of the petitioner. Mr. नाम बताइए अपना भूलिए अपना नाम
राजवर्धन
Rajvardan, advocate, submits that as per the writ order, the direction was issued to पूरा नाम दे देंगे authority का भी लिख के दे देंगे. But the state authority has not been made a party in the present proceedings. Office is directed to make the approaches authority as party in the proceedings by inserting the name of the approaches authority as opposite party number 15. उनका नाम भी तो नहीं होगा ना नाम है
नाम नहीं है
कोई बात नहीं 15 ऐसे कर Mr. Rajvardan undertakes to file show cause / compliance report. आपको भी कुछ करना है
Direction is नहीं
The learned counsel for the state has submitted that then in view of the submissions made by Mr. Rajvardan, the state need not file any. The authorities of the state need not file any show cause in the matter as of now. Post this case on बताइए कब करेंगे? Post this case on 13th June.
Yes ma'am.
The show cause / compliance report by the newly added opposite party be filed by 10th. By 10th of June. By 12th. Office is directed to print the name of Mr. Rajvardan. किनका आपका? किसका? Mr. Krishna Murali. इनका junior counsel to Mr. Krishna Murali. नाम आ रहा है? उनका नाम आ ही रहा है।
जी
ठीक है 13 को रहेगा आपका compliance report आएगा। आपको अपने अथॉरिटी का नाम नहीं पता कंटेंट में बाय नेम
he not made a party ma'am so I that
अच्छा कोई बात कंप्लायंस पे ध्यान दीजिए
yes
ये फॉर्मेलिटी को छोड़ो वो नाम लिख के दीजिए पूरा हाँ आपका क्या हुआ बताइए किस दिन भेज देंगे
On Friday, Your Lordship, because
Next Friday is 11 o'clock.
11 o'clock ऐसे नहीं करिए किसी को सुन के ऑर्डर करना है ना
exactly.
सुन के करिए नहीं पसंद आए तो रिजेक्ट कर दीजिए लेकिन बिना सुने मत करिए
Letter there, तो वो appear नहीं करे, that's why your addition.
Content Civil 323 of 2025, the learned counsel for the parties are present. The learned counsel for the opposite party has submitted that the order of this court has not been complied so far in view of the fact that in spite of repeated notices, the petitioner has not appeared for hearing. At this counsel for the petitioner has no no instructions. However, he submits that if any date is fixed by this court, there will be no communication gap and the petitioner would ensure his appearance for the purposes of hearing. He submits that there can be no reason as to why the petitioner is not appearing. There can be no reason for non-appearance on the part of the petitioner. There could be some communication gap in service of notice of hearing to the petitioner. Okay? At this, the counsel for the opposite party has taken instructions and has submitted that if the petitioner appears before opposite party number,
Opposite party number 3. Executive list.
opposite party nahi,
In the rate order, Your Lordship, it's party number 3 executive
आपने
which is
तो
the national division.
नहीं किया है, पार्टी नहीं बनाया. Before the executive engineer, National Highway Division, Government of Jharkhand. ये तो respondent number 2 को था.
Respondent number 2.
Secretary को था.
Secretary is that, but the petitioner has been retired from the Medinagar division, so the concerned officer.
जिसको डायरेक्शन है उसी को करना.
Secretary is the party.
ऐसे नहीं है, जिसको डायरेक्शन है उसी को करना. बताइए.
Then we have to take
instruction that the secretary, because the concern inquiry has been conducted by the executive engineer and he will submit the report before the concern OP number 2. Then he will pass a reason order according to the same inquiry which made by the executive engineer from the division of the Medinagar.
Hearing जो करता है उसी को order pass करना.
So because the methodology they have adopted is not a proper methodology because the petitioner has to appear before the secretary.
The leadership may direct us, we will communicate the same to the officer.
He has submitted that he has taken instructions that if the petitioner appears before the executive engineer, National Highway Division, Government of Jharkhand, Medinagar, then a brief can be prepared so that the matter may be placed before the opposite party number 2, who may give hearing and pass out of paper. Okay? Counsel for the petitioner undertakes to appear before the executive engineer, National Highway Division, Government of Jharkhand, Medinagar, for the purpose of presenting his case and so that a brief of his case be prepared. However, it is made clear that the order has to be complied by the Secretary, Road Construction Department, and the petitioner has to be granted hearing by the Secretary for passing the reason. The petitioner will also furnish his email ID such that the date of hearing is promptly communicated to the petitioner through email. That's
his mobile number or email ID.
क्या चाहिए आपको?
Mobile number and mail ID both may be indicated in the order sheet.
Mobile number and also email.
It's date may be mentioned, it's 9th.
9th of
He shall appear on 9th of May
On 11th.
2025 at 11 a.m. It will take some time.
Yes.
So therefore, I am posting it on 18th of July. Post this case on 18th of July. In the meantime, the compliance report will be filed by 15th of July by opposite party number 2. Annexing a copy of the reason.
Appearance देखिए. For hearing under order 41/11 item 29, second appeal 102 of 2022.
May I please? Lordship, in this matter, at the outset we were praying for one adjournment to get prepared in the matter. This is the second appeal. I have lost in both the courts below, Lords. Suit was filed by the defendant, the respondents, Lord, for declaration of their right, title and interest, Lord, and permanent injunction against the appellants. That was decreed. I preferred appeal. Appeal has also been discussed. One of the substantial question of law that is involved is not whether the appellants have perfected their right title by virtue of adverse possession, because as per their case, they are in possession for more than 80 years. Only to get prepared, I was seeking one adjournment.
The learned counsel for the appellant seeks adjournment to prepare himself in this case. When do you have?
But any date after the issue.
Assigned matter है. Assigned matter है.
Perhaps not.
Post this case on 1st of December.
Item 30, second appeal 202 of 2023.
My lord, I am praying for now that the RP council there has been sudden death in the family and he has left to his village.
Mr. नाम बताइए.
Mr. PC.
Your name is
Also, my good name is Shiv Shankar ji.
Shiv Shankar.
G. JW.
Shiv Shankar G. And Mr. PC Roy. He was involved with this case.
Yes, my lord. He was engaged by advocate only.
When will he be available?
Your lordship, any day after Monday. In the next, any day after Monday.
SA number 202 of 2023. Mr. Namdija submits that the arguing counsel, Mr. PC Roy, is not available to argue this case on account of bereavement in his family. He seeks adjournment. Post this case on 1st of December.
For hearing item 31, WPS 584 of 2012.
Yes, petitioner.
Established for dismissal from service of the police constable. Discuss section 1 before starting the matter. I would like to draw my lord's attention that due to inadvertent mistake, because the state petition was filed in 2012. The impugned order that has been mentioned as memo number 179 dated 1/2/2003 in our prayer portion matter. This order has already been quashed in the previous round of litigation, and subsequent thereto a fresh order has been passed, and that order has not been challenged in this litigation.
The improved order has already been quashed, and simply say this. And this is the liquidation.
That is quashed or not, that is also doubtful, because it has been mentioned in Annexure 4 that it should go. It is proper to quash the order dated which is not according with the in my leadership, C page 46.
Yes, and I have page number 46.
Second last paragraph. In view of the aforesaid reason, it would be just and proper to quash the order dated so and so which is not in accordance with the terms and conditions contained in the judgment of the time. So it is specifically not being quashed actually, as far as I understand.
Then what happened? The review was.
Yes, thereafter we preferred a review, and the Annexure 5 has been passed again affirming the order of dismissal. And this order has not been challenged in this.
So that's right. They have taken it as quashed only.
Yes.
They have considered the review petition,
Review
and
has
the
been-
review has been rejected.
But-
There is a subsequent development which is not under challenge in this proceedings.
Yes, that has not
The
been
review
challenged.
has been entertained.
Review has been entertained, yes, right. But the dismissal still exists there.
Certainly, review has been rejected, and that review order is not under challenge.
But this is the fact which I brought to your knowledge, because the client is
Nothing
also
can be done. We just can't do anything. You have not challenged the review order.
since 2012 is
एंड फोन भी नहीं करता होगा।
नहीं, ये तो हम तो सब ज्वाइन भी नहीं किए थे।
नहीं मिलेगा। पीपल सेटल विद ऑल दिस।
तो एक बार लेटर लिख के अगर
कुछ लेटर से क्या होगा, बिना अमेंडमेंट के तो होगा नहीं। अब हमने अमेंडमेंट अलाउ करने लगे।
बस यही है फैक्ट। फाइनल जो रिव्यू ऑर्डर है वो चैलेंजिंग है।
इसके बाद आपको रिट का ऑर्डर फाइल करने के लिए ऑर्डर हुआ CWJC नंबर 3358।
वो तो उसके बाद ये
आपने फाइल किया था ना?
हाँ वो सब हो गया।
कहाँ है 3358 का ऑर्डर?
वो एनेक्सर 2 है।
एनेक्सर 2
3897 of 95
3897 3358 of 1989। Where is that order?
That order is not available. That was remanded back on the for giving proper opportunity to the petitioner and thereupon to pass up this order. First round of litigation it was, because the impugned order was passed without providing an opportunity and therefore that order was brought in the first round. This is the fourth round of litigation.
That petition was dismissed.
Second one also dismissed, but it was remanded. Minor premises the annexure to this is also dismissed, but the matter was said.
है नहीं देखिए आपको
हाँ
पता
है कुछ वैसा कुछ खास नहीं।
ऐसा कुछ है नहीं और ये ऑर्डर से ही लग रहा है कि
चार्ज इतना ही था, बस एक लाइन में समझा देते हैं कि 180 रुपए का फॉल्स ये बिल निकाल लिया।
काफी।
हाँ वही बस चार्ज है, उसी के बेसिस पे घूमते रहे हैं।
काफी काफी
बस
पकड़ाए हैं एक में, पता नहीं कितना किए।
नहीं 180 रुपए का ही टीए बस बनाए थे इलेक्शन
क्या पता?
ड्यूटी। नहीं वो प्रूफ हुआ है।
वो प्रूफ हुआ है, बाकी का क्या पता।
बाकी
एक बार जो आदमी झूठ बोलता है और एक बार जो आदमी पकड़ा जाता है, उसका पूरा का पूरा पर्सनालिटी क्वेश्चन है ना। वेरी डिफिकल्ट। Heard the learned counsel appearing on behalf of the petitioner, nobody appears on behalf of the respondents. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that there has been several rounds of litigation and the matter relates only to raising false bill of rupees 180. He has also submitted that the petitioner was subjected to disciplinary proceedings. The petitioner was initially appointed as constable way back on 13/12/1972 and the allegation regarding raising false bill was made in the year 1986, and the petitioner was charge sheeted by charge sheet dated 11/5/1987. Disciplinary proceeding was initiated by departmental proceeding number 42 of 1987, and ultimately the petitioner was dismissed from service, which was challenged in writ petition being CWJC number 3358 of 1989, which was disposed of by the order dated 2/5/1989, whereby the concerned authority was directed to pass fresh order after granting an opportunity of hearing. The appeal was also dismissed by the order dated 26/8/1989. The petitioner filed revision as well as memorial before the competent authority, but the same was also dismissed. The petitioner ultimately filed the petition being CWJC number 3897 of 1996 within bracket R, which was ultimately (3897). Dismissed by judgment dated 12th of August 1998. However, there was an observation that the petitioner can very well file a review petition. The fresh order, thereafter another order dated 1/2/2003. ये कौन सा order है? 1/2/2003.
1/2/2003 जो क्वेश्चन हो गया पिछले राउंड ऑफ लिटिगेशन नेक्स्ट 3 में
Just a minute.
नेक्स्ट 3
The review petition was also dismissed by the order dated 1/3/2003. 1/2/2003. The same was subject matter of the petition being WPS number 4790 of 2003. The Learned Council has submitted that the Director General of Police Jharkhand was directed to decide the review petition in the light of the observation made by Patna High Court in order dated 12th of August 1998, passed in CWJC number 3897 of 1996 within bracket R, as the state of Jharkhand has been reorganized. He submits that the fresh order has been passed, which is contained in Annexure 5, whereby the review petition has been rejected. The fresh order is dated 17th of March 2011. The Learned Council has submitted that. The fresh order has not been challenged in this petition, and what is under challenge is the earlier order dated 1/2/2003, which was subject matter of WPS number 4790 of 2003. This court is of the considered view that pursuant to order that the order dated 1/2/2003 was challenged before this court in WPS number 4790 of 2003, and a direction was issued for filing fresh order on the review petition on account of reorganization of the state of Jharkhand. The same has already been passed by order dated 17th of March 2011 as contained in Annexure 5 by citing reasons, and the subsequent order having not been challenged and the order dated 1/2/2003 has already been taken care of by this court in WPS number 4790 of 2003 with the direction to pass a fresh order of review. Therefore, no relief as prayed for by the petitioner in this petition can be granted. Consequently, this petition is hereby dismissed. आपको ऑर्डर लिखाने के बाद आए हैं क्या जिसका आप कर रहे हैं? क्या लिखा है आपकी तरफ से?
पैराग्राफ 2021-22
The learned counsel for the state has referred to paragraph 20, 21 and 22 of the counter act. Mr. Pravesh Kumar, Serving for the state.
Item 32, WPL 3090 of 2015.
Yes, petitioner. Yes, you are for the respondent. Where is the petitioner? Who is for the petition? What is the matter about?
The prayer is for quashing a award dated 29/9/14 of CEIT, by which it has refused to regularize the workman concerned. The schedule was whether the safai work not be carried out by the management of Puri Town Administration of BCCL through cooperative societies in spite of circular dated 13/3/90 of their own organization is fair and justified. What reliefs are the workers of concerned cooperative societies entitled?
WPL number 3090 of 2015. Nobody appears on behalf of the petitioner. The learned counsel for the respondents are present. In order to give one more chance to the counsel for the petitioner, the sign number raised this case on 2nd of January 2026.
Item 33, WPS 6020 of 2016.
For the respondents.
We have already paid Malad as per the contribution given. Certain contribution was not indicated by the full management, and therefore we have asked for that.
Sorry?
Well, in this case, there is a revise of pension for that CMP. We have said that we have written a letter to the clearing management to furnish the detail of the contribution given by the management as well as by the employee, which has been not given to us till now.
Who is for the management?
Your Lordship, I am waiting for BCCL.
बताइए, आप इनको कम्युनिकेट नहीं करते? Where is your counter?
My counter is, I have already submitted given contact.
बताइए कौन सा है कॉन्ट्रैक्ट?
2018 में फाइल किया।
Just
Paragraph 12.
just a minute. इन्होंने एक सप्लीमेंट्री एफिडेविट फाइल किया है।
Filed on 10/2/2022.
सॉरी,
इसमें क्या लिखा है?
31/8/22। 31/8/22 का इनका एक कॉन्ट्रैक्ट है। Respondent number 124 had filed a supplementary contract affidavit on 9/2/22. आपको मिल गया?
Responding का petitioner का है एक joint contract में
ये कॉपी आपको नहीं मिला? पी के मुखोपाल में आपको नहीं, आप
पीके मुखोपाल का petitioner है
आज इनको नहीं सर्व किया।
Supply
आप जरा इनका सप्लीमेंट्री कॉन्ट्रैक्ट भी पढ़ लीजिए, घर पे टाइम नहीं मिलेगा। ये रिजॉइंडर जो है इनका
उसी
पढ़ लीजिए, कम से कम समझे तो उनका क्या केस है। जस्ट रीड इट करो। पढ़ी पढ़ी जोर से पढ़ी।
The petitioner did not submit the paragraph 4 से ये हमको पब्लिश कर दे, हम इसका रिस्पॉन्स कर
नहीं ना पढ़ी ना,
लो,
तो
कहाँ
नहीं
पर?
टाइम
हाँ हम देखें नहीं
कोई बात नहीं, अभी देखेंगे साथ साथ। पढ़िए पढ़िए, ज़्यादा नहीं है, 4-5 पन्ना है, पढ़िए।
The petitioner did not proceed in the offered for the payment of the full statement of the entitled to the amount according to has filed an application with the central government never to the part under section which is registered and accessible by the
कौन सा एफिडेविट?
5
नहीं, ये जो एफिडेविट सप्लीमेंट्री रिजॉइंडर टू काउंटर एफिडेविट
ज्वाइंट सप्लीमेंट्री दे रहे हैं
उनका केस समझना है ना, इनका केस तो नहीं। अब इनका उनका पिटिशनर का केस समझना है।
उसका किसका सप्लीमेंट्री रिजॉइंडर टू द काउंटर एफिडेविट इसका
बताइए, पेंशनेबल सर्विस इन्होंने इसमें किया है, उसका पैरा 4 से पढ़िए।
जी exactly is the further stage of the eligibility of insert to the employee as an independent clause 4 of the scheme that is the further stage of the conflict clause 10 of the scheme subclause 1 and employee after the service and attaining the age of supervision and eligible to receive pension at the rate of 25% the average or less or not less than rupees 350 from the date following the date of supervision like the date of line the date of the which is stated in the listeners was appointed in service of her 73 that it is also effect from 1 11/12/2009 from the service of Bharat Petroleum to the block of the area out of our that is the DC control servicing the area of customer service of that is the counter fiber responding to 5 just only one. And through Lecture 8 to the corner that I have with paid for the last 10 preceding month has been determined and certified by the finance manager establishment in the area of Nagpur of Bharat Petroleum and Vietnam Port. That is knowledge in detail of pension contribution and rechargeable report at page 11 of the opposite counter to show that the system that onward the family members has been deployed in the name of the petition. That is the total pensionable service as shown in Annexure B of the said counter and is absolutely legal and based on the future adventure of the Bharat Cooking Coal Limited and instead of paying of 25% average pay this amount to be such and such but illegally reduced and fixed and paid at the rate of rupees 1 thereby causing loss to the prisoner of such and such about months going well the amount in the date of superannuation till date. Although the respondent received the dues with interest from given back whether it is there on the same due and pension. That it is always stated that the petitioner compelled to file and see application such and such with the implementation of the right and payment of cooking level as the right such and such in request to such modified by this on report and order is that it is stated in my order get to such a past agency application was passed by the London Labour Court magically manner accepted the contents of the employee instead of calculating instead of in term of the mandate of the provision of section 33C2 of the Ministry Dispute. That is stated that the order created 27/11 was challenged by final notification of such before this order by order such. Once the order reminding the matter directing the Labour Court to take a fresh decision as per the mandate of the section 7 of the Ministry Dispute and Settlement has to be made by the Labour Court. This order that it is further stated that the decision of the application of the decision on the determined from wage fixation of the petitioner the average wage prior to the superannuation on the which subsequent count the enhancement of the monthly payment of the petitioner automatically since that is date of superannuation date. That it is stated that the part 12 and 13 of the counter affidavit of respondent number 1 to 4 read with annexure B hearing the petitioner will be entitled to consider enhancement in the monthly pension. That it is stated the business statement.
Now, if we see the nature of the petition, he is seeking a mandamus.
Lots.
At the same time, he has filed a representation before the general manager Kusundai. So,
इसमें एक ही इशू है कि हम लोग कह रहे हैं कि हम लोग देंगे बशर्ते आपको अपना जो कोल कंपनी है उनका अपना कंट्रीब्यूशन का डिटेल हम लोग को फर्निश करें जिसके लिए हम लोगों ने उनको लेटर दिया. नाउ वेदर दे हैव फर्निश दिस और
what do you have to say? You have furnished the details of the deductions.
Actually, we have filed a supplementary counter affidavit in which we have given the details of the deductions that have been made and forwarded to respondent.
Where is your supplementary counter affidavit? This is dated.
It's dated 10/2/2022.
Where is the details? Page number?
The calculations we have made at paragraph 4 in page number 5, 18/20/2004 that although back wages were to be paid with effect from January 1993, but the respondents have calculated back wages for the period commencing from 1/12/1992 to 28/1/2004. The gross
Supplementary counter affidavit of respondent number 1 to 4, dated 9/2/22.
yearly.
You are referring to para number?
Page number 5.
Page number 5.
Dates are given.
Okay, dates are given. Okay, this is what you are referring to.
Yearly. should I read out the list of dates?
No, that's okay. So, where is the problem now?
Also, kindly see my annexure D of my contract, which I am permitted to read. Also, in this, we have written to the finance manager, Kusunda area office, PO Kusunda district, Dharwad, Jharkhand, pension claim in respect of Amal Kumar Datta, CMPO such and such. Sir, with reference to your office letter number such and such, dated 10/7/2010, you have submitted a supply PV in respect of above said member in which FPC in so rupees 2076 for back wages period. In pension contribution sheet from CPE 85 to 92, FPC column is black. We have said lots of got it.
This is annexure D, page 16.
So we have asked that this is blank. So we said you are requested to intimate whether FPC amount is calculated year-wise with penal interest along with breakup of calculation. You are also requested to confirm the period for which above amount deposited at FPC column is blank for 85 to 90. So lots of we say that only you have to furnish the detail whether you have given the contribution or not. So they have to reply on this.
What is your response to this document?
Lots will find that prior to that we have given the seat also, that is running page 11, where lots will find that is a blank 11. At the pension contribution, both here, that is blank 85 to 92, which we are referring to. That's why this contribution is
85 to 92 is blank.
that we want to reply.
Only that much will suffice?
If they will furnish, then we will respond for that. So this is required.
What is your specific reply? You come to page number 52 of the counter affidavit. Page number 11 of the counter affidavit filed by them, which is dated 13/7/2008. $385 to $392 is blank.
It is blank.
So you have to respond to this. बाकी तो सब आ गया है और भी blank है. You see 385 अच्छा 392 यही figure blank. Correct? Got this?
Yes, sir.
Nobody appears on behalf of the petitioner. The learned counsel for the respondents are present. The learned counsel for the respondent CHPA has referred to affidavit counter affidavit dated 2/7/2018 filed by respondent number 5 and 6 and has in particular referred to internal page 11 of the said affidavit, which is at running page 52 of the brief, to submit that there is no clarity on the part of the respondent BCCL with respect to the contribution for the period from 3/1983/85 to 3/92. He has also referred to running page 57 and internal page 16, which is a letter dated 1/4/2013, which was written by the office of CMPA to the respondent BCCL seeking clarification with respect to the aforesaid period. He submits that no response इसका response आया था आपने लगाया है. he submits that in response, though a letter has been received, but there is no clarity in connection with the apposite. Counsel for the respondent BCCL submits that he shall seek instructions and file a supplementary counter affidavit explaining the entire thing. He prays for 4 weeks time.
Yes.
Pose this case on 13th of June. The affidavit should be filed by 8th of June.
Madam, first week I'm doing some deadlines. If it was a third week also, I'm doing something also.
On 20th of June. The affidavit should be filed by 10th of June. हो जाएगा? इसको भेज देंगे हम लोग जल्द से अकाउंटिंग करा लेंगे। कुछ समझ के आई?
Let me receive instructions.
Item 34 WPS 2580 of 2017.
क्या है?
Dismissal.
क्या मैटर?
The petitioner was appointed on the post of police constable on 15/10/1997 on compassionate ground in place of his father. Thereafter, in the year 2005, charge sheet was slapped upon the petitioner on the pretext that since 28/1/2005 he is remaining unauthorized absent. This was the allegation, my lord. Arop annexed to page 23. Thereafter, my lord,
रीट पे कौन सा ऑर्डर हुआ?
जी,
It is the writ order.
writ order annexure 6. The writ was withdrawn with liberty to file a review memorial revision before DGP, and after that we filed a review before DGP, and my lord, the same has been dismissed on the ground of being time barred. And this is the reason because all this while, my lord, since 2005 the petitioner was admitted in RIMPAS, my lord, he was undergoing mental illness, and certificates also he has annexed in annexure 1, my lord. Thereafter, without going into the applying the provision of Rule 843 of the police manual, the petitioner was suspended. The Rule 843 says that within 1 week from the date of absence, if any person is absent, my lord, then the concerned superintendent shall make a visit to his native place, and thereupon Rule 843, my lord, as a rule whenever any
आपका मेमोरियल जब टाइम बार्ड हो जाता है हम लोग क्या करते हैं?
टाइम बाद था, इसीलिए तो हम हाईकोर्ट में रिट फाइल किए थे।
तो क्यों विड्रॉ किया?
विड्रॉ के लिबर्टी लिए थे
लिबर्टी था एज पर रूल्स।
बिकॉज 6 महीने का टाइम होता है। हम मेंटल इलनेस में थे जब हम ठीक हुए 2008 में, हम वो भी सर्टिफिकेट लगाए। जब ठीक हुए तब तक वो पीरियड एक्सपायर हो चुका था 6 महीने वाला। बिकॉज एज पर रूल जो 2005 में वो डिसमिस किए तो हमको विद इन 6 मंथ्स स्टैट्यूटरी पीरियड अपील करना था, वो एक्सपायर हो गया था, इसलिए हाईकोर्ट आए। हाईकोर्ट से हम लिबर्टी लिए कि
हाईकोर्ट भी तो 2008 में है।
हाँ, तो 8 में ही तो हम ठीक हुए, तभी तो हम सब जगह
आप
अप्रोच
बोले
कर
6 महीना में तो
नहीं,
2005 में डिसमिसल हुआ,
6 महीना में हमको अपील करने का पीरियड था, वो एक्सपायर हो गया। हम 8 में जब ठीक हुए तो हम अपील कर नहीं सकते थे बिकॉज स्टैट्यूटरी पीरियड एक्सपायर था, तो हम हाई कोर्ट में रिट फाइल किए। फिर उस रिट को विड्रॉ किए कि विद लिबर्टी टू फाइल अ फ्रेश।
Accordingly, this writ application is dismissed and withdrawn with liberty to the petitioner to approach a competent authority as per relevant provision of.
Yes, under 853 I approved the DGP, and now the DGP has again dismissed the appeal on the ground of time bar. He says कि 10 साल 12 साल हो गया तो it is a time bar. Time bar तो है, वो that is an admitted fact. Time bar तो पहले ही हो चुका था. So at least my lord की this impugned order which we have annexed, the order of DGP which has been dismissed on the ground of being time barred, this may be quashed and matter may be remanded back to the DGP to decide on its own merit after giving an opportunity of being heard to the petitioner. If at all he has all the documents, he can provide it there, because in that departmental proceeding was conducted behind his back, my lord. He was all along.
all the documents इतना stale हो गया आपका claim. All the documents कहाँ से क्या आएगा बताइए? मुश्किल है ना ऐसे में documents. अब ये लोग कितना साल तक अपना आपके documents रखे रहेंगे?
तो उस पर हम नहीं जाते. हम बोलते हैं कि 843 अप्लाई करके ये वेरीफाई कर लेते हैं कि हम कहाँ हैं. हम स्वेच्छा से भागे हुए हैं या फिर आई एम अंडर का ड्यूरेस. That they could have done under 843.
नहीं, और आप जरा देखिए हाई कोर्ट का ऑर्डर हुआ है 2015.
25 जून 2015 को. डिसमिस एक साल बाद हुआ है 2016 में 3/10/16 में.
कंपल्सरी रिटायरमेंट.
हाँ कंपल्सरी.
एज ऑफ रिटायरमेंट भी पार हो गया होगा.
नहीं रिटायरमेंट तो
डोंट थिंक कैसे हो ही गया होगा. 2006 में आपका कंपल्सरी रिटायरमेंट हुआ है.
हाँ 97 में अपॉइंटी है. 2006
कॉम्पैक्टेड अपॉइंटमेंट का तो कोई एज का कोई क्राइटेरिया.
हाँ उसमें क्राइटेरिया नहीं है. ये तो मेजर पनिशमेंट.
एज बताइए.
But the thing is that he was appointed in a much younger age of probation. So I don't think if there is an age of supervision would have been attained.
कितना टाइम किया हुआ है रूल 853 में?
6 महीने.
रूल 853 में 6 months.
6 months इसमें अपील करने का पीरियड होता है.
और रूल 853 में कितना टाइम? 1 month.
853 में तो रीजनेबल टाइम. 853 में रीजनेबल टाइम नहीं होता. I don't see it. Memorials and revision. No memorial or petition which is a representation against an order passed in disciplinary case shall be submitted to an authority other than authority which under the rule for the time in force is about to entertain the appeal, provided that an officer of rank not equal to the rank of SI may, if a final order for dismissal, removal or reduction in rank has been passed in appeal against him in a disciplinary case, submit to government through proper channel against such order within 6 months after the date of which the officer submitted the memorial was informed of the order on appeal. Provided further memorial of an below rank of ASI. 853 अपील के बाद वाला प्रोविजन होता है मेमोरियल रिवीजन में. और अपील का प्रोविजन 851 में 852 में नो. Within 6 months after the date on which the officer preferring the appeal was informed of the order against which he appeals. 852.
ये 853 ना तो मेमोरियल की बात कर रहे हैं.
हाँ मेमोरियल.
तो
मेमोरियल में भी 6 महीना ही है. 6 months. Within 6 months after the date on which the officer submitting the memorial was informed of the order on appeal.
और आपने ये मेमोरियल का फाइल
ऑर्डर के जस्ट बाद
Where is your memorial?
that is not in the job.
तो क्या देख के आपका ऑर्डर पास हुआ? और आपने कब फाइल किया
मेमोरियल ऑर्डर हाईकोर्ट ऑर्डर के बाद ये जो हाईकोर्ट से लिबर्टी
हाई कोर्ट ऑर्डर के 6 महीना बाद फाइल किया कि 6 महीना पहले?
6 महीना बाद हो
तो फिर अगर 6 महीना भी काउंट करें
ये
हम
टाइम
हाई कोर्ट ऑर्डर
ये टाइम बार किस लिए कर रहे हैं वो लिखे हैं कि ये जो फाइनल ऑर्डर जो पास हुआ है उससे 12 साल पार हो गया है, उस टाइम से काउंट कर रहे हैं वो टाइम बार।
हम काउंट कर रहे हैं जो हाई कोर्ट के ऑर्डर से। एट बेस्ट इसके बियॉन्ड तो आप नहीं जा सकते ना फिर। और आपका मेमोरियल क्या था वो भी नहीं लगाया, तो क्या चीज का हम ऑर्डर पास करें ऐसा हवा में? इवन द मेमोरियल इज नॉट ऑन रिकॉर्ड। इतना पुराना रिकॉर्ड तो ये हम लोग नहीं एक्सपेक्ट करते हैं कि ये लोग। देखिए आपका अपील डिसाइड हुआ था 2006 करेक्ट?
टू 2006 में डिसिप्लिनरी ऑपरेटिंग पनिशमेंट इम्प्लीमेंट किया था। उसके बाद हम अपील किए ही नहीं
और सीधे रिट पिटीशन।
हाँ, हम सीधे रिट पिटीशन फाइल किए जब हम।
तो फिर आप अपील क्यों नहीं किए?
क्योंकि उस पीरियड में हमको आई वाज अंडरगोइंग ट्रीटमेंट फॉर इंसैनिटी में।
नहीं किए तो रिट पिटीशन में भी तो बोलते हैं ना कि हमको अपील में जाना है। आप तो सीधे मेमोरियल में चलने के लिए तैयार हो एज पर रेलेवेंट प्रोविजन।
अपील में
and you withdrew the writ petition after some argument. एब्सेंस कितना दिन का है?
28/1/2005 के बाद टिल पासेज ऑफ ऑर्डर दैट इज 2/3/2006।
छुट्टी लेके गए थे?
नहीं, छुट्टी लेके नहीं गए।
ऐसी बात है।
भगोड़ा इसलिए तो ये लोग
नहीं भगोड़ा तो दोनों तरह से होता है ना। छुट्टी लेके गए ओवरस्टे तो ओवरस्टे के लिए इंक्वायरी किया। भगोड़ा के लिए कहाँ इंक्वायरी लिखी? जिस रूल का आप रेफर कर रहे हैं हमसे तो ज्यादा आप ही को पता है। इंक्वायरी किया जाता है उसके लिए जो छुट्टी पे जाए लौट के लिए, जो भाग जाए उसका क्या इंक्वायरी करना है हमको बताइए। जो ड्यूटी छोड़ के भाग जाए उसका क्या इंक्वायरी?
लेकिन ऐसा कुछ वर्ड है उसने कि रूल में कि ड्यूटी से
कोई बात नहीं, हम इंटरप्रेट कर देंगे आपके लिए फॉरएवर एक एसेट हो जाएगा। उसको इंटरप्रेट करके आपको रिलीफ दिया ना, तो फिर लाइन उसमें कहाँ लिखे हैं कि भगोड़ा को भी मिलेगा? ऐसा हम लिख ही नहीं सकते।
वो नहीं।
If he does not join the duty,
does not return
overstay, does not return for duty, जो भगोड़े के लिए तो ये रूल एप्लीकेबल ही नहीं होना भी नहीं चाहिए ना। लॉ बना है जो लॉ मानते हैं उनके लिए नहीं कि जो काम छोड़ के भागते हैं। आठ साल के सेवा काल में 8 पुरस्कार के बदले लघु एवं क्या 8 पुरस्कार के बदले
2 लघु एवं 4 बृहद सजा मिली। 2 माइनर एंड 4 मेजर पनिशमेंट। और नीचे दिया हुआ है कि अवकाश पहले ही पिछड़े एक बार 1 दिन के लिए, एक बार 5 दिन के लिए। भगोड़ा अवधि
So this is an admitted fact.
Yes, this is.
और कहाँ है चार्जशीट?
यही है नेक्स्ट टू पेज 23 आरोप प्रारूप।
पढ़िए सर।
इन्हें दिनांक 4/1/5 को 15:00 बजे हवलदार बिंदेश्वरी सिंह द्वारा वाहिनी परिषद में फटीक ड्यूटी सुनाया गया, तो ये बोले कि हम फटीक ड्यूटी नहीं करेंगे, आपको जो करना है कर लीजिए। दिनांक 6/1/2005 को वाहिनी मुख्यालय द्वारा उनकी 16 से 18 बजे तक आरपी ड्यूटी थी, लेकिन दैनिक पदाधिकारी अनिशा पृथ्वी चंद पासवान द्वारा पोस्ट चेक करने पर ये ड्यूटी पर तैनात नहीं पाए गए। वाहिनी परिसर में खोजबीन करने पर भी इनका पता नहीं चला, तो इनके स्थान पर सिपाही 102 रमाकांत तिवारी को ड्यूटी में तैनात किया गया। कि वाहिनी मुख्यालय परिसर से बगैर सूचना एवं अनुमति के स्वेच्छापूर्वक दिनांक 28/1/2005 अपराह्न से भगोड़ा है। इन्हें पदादेश संख्या 1600 के क्रम में दिनांक 28/1/2005 को वाहन से निलंबित किया गया। इन्हें अपने 8 वर्षों के सेवा काल में 8 पुरस्कार के बदले 2 लघु एवं 4 बृहद सजा मिली है। 2 बार कर्तव्य से भगोड़ा हुए हैं तथा 2 बार अवकाश से पिछड़े हैं, जिसकी विवरणी निम्न प्रकार है। अवकाश विलंब 16/8/2002 पूर्वाह्न से दिनांक 22/8/2002 7 दिनों का
अवकाश विलंब क्या बोलते हैं?
मीन्स
ओवरस्टे
को ईएल में कन्वर्ट कर दिया गया ये 2 इंसिडेंट्स में, और नीचे वाले 2 इंसिडेंट्स में 2 माइनर पनिशमेंट दिया गया।
ran away from duty क्या बोलेंगे सर? भगोड़ा
अवधि 28/1/2005 से माना जाए।
ran away from duty ना?
हाँ, ran away। Absconder
कुछ केस आपका बनता है, आपका ये जजमेंट मिलेगा। आप तो जो जजमेंट नहीं साइड किए थे वो सब भी हम साइड।
हाँ, हम देखते हैं
क्या करेंगे, आप कुछ साइड ही नहीं करते, तो हम लोग को अपने रिसर्च करना पड़ेगा।
किशोर सिंह
फोन में जजमेंट खोजिएगा, 1 मिनट भी नहीं होगा आपको जजमेंट मिल जाएगा, खोजते नहीं आप। उससे क्या होगा? अब 843 का इंटरप्रिटेशन आपको चाहिए, क्या होगा बताइए?
किशोर सिंह वर्सेस स्टेट ऑफ झारखंड, और ये जून 2000 लगता है कि ये बीएल या साइड।
हाँ, सब करना पड़ता है ना आप लोग को। क्या करेंगे? आपको नहीं करेंगे तो आपके पुलिस डिपार्टमेंट में इतना काम करता है, तो ये सारे जजमेंट्स एकदम वॉल्यूम्स में होना चाहिए। फिर ये भी चेक करना पड़ता है कि ओवररूल हुआ है कि नहीं। अभी तो लोग अपील में गए होंगे इसके अगेंस्ट। और आपको कुछ बोलना है? हाँ, क्या बोलना है?
We oppose the definition and delay part is earlier the petitioner was has filed the writ petition, and that in that writ petition court did not condone the delay. The court directed to approach before the higher authority, and they will take this. They did not condone the delay part.
The main order is also under challenge. That makes no difference. The earlier order, 2/3/2006, is also under challenge.
It has been challenged.
heard the learned counsel appearing on behalf of the parties, this petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was inflicted punishment by order dated 24, punishment of compulsory retirement by the order dated 24/12/2005, which was challenged 2005 है ना?
Then there is 2/3/2006.
By the order dated 2/3/2006, which was challenged by the petitioner in the petition being WPS number 6073 of 2008. However, the same was withdrawn after some argument by the order dated 25/6/2015 with liberty to the petitioner to approach the competent authority as per relevant provision of police manual. The learned counsel submits that the petition in terms of rule, council rule 853 was filed, but the same has been dismissed by holding that the memorial was filed,
The same is time barred.
that by holding that it was barred by limitation. The learned counsel has referred to Rule 853 and submits that there is a period of 6 months prescribed to prefer the memorial, but the petitioner had preferred the memorial pursuant to the order passed by this court. The learned counsel has also submitted that the main order dated 2nd of March 2006 is also under challenge in the present proceedings. He has relied upon Rule 843 of the Jharkhand Police Manual and has submitted that no inquiry as to the reason of not joining the duty was conducted and the proceeding was held ex parte. He has submitted that the petitioner was suffering from mental disease and therefore the absence was not willful and consequently the impugned order of dismissal
Compulsory retirement.
of compulsory retirement on account of absence from duty is fit to be satisfied. He has relied upon the judgment passed by this court in WPS number 6652 of 2014 decided on 21st of March 2025. The learned counsel appearing on behalf of the state has opposed the prayer and has submitted that memorial was required to be filed within a period of 6 months and the order of dismissal was 2/3/2006 and the writ petition itself was filed much after expiry of 6 months, only in the year 2008. He has submitted that the order passed by this court, whereby the writ petition was withdrawn dated 25th of June 2015, did not indicate that the delay was to be condoned. The learned counsel has also submitted that. Otherwise also, the impugned order dated 2/3/2006 does not call for any interference. He has submitted that as per the charges leveled against the petitioner, he was asked to perform his duty on 4/1/2005, but he refused to perform his duty and then absented himself. It is not a case where the petitioner had taken leave and subsequently not joined for duty, and therefore the provision of Rule 843 also is not attracted. He has submitted that once a person He has also submitted that the previous record of the petitioner regarding overstay and absconding from duty was also a part of the charge, and the petitioner was punished twice, no, 4 times. 2 times minor punishment was imposed and 2 times major punishment was previously imposed. The learned counsel has submitted that no case is made out for interference under Article 226 of the Constitution of India. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that as per the charge, the petitioner was asked to perform his duty, but instead of performing his duty, he ran away from the work and remained absent till his date of dismissal, a compulsory retirement on 2/3/2006. This court also finds that the disciplinary proceedings was conducted and apparently the petitioner did not participate in the proceedings. Did not participate in the proceedings. The order of the disciplinary authority of compulsory retirement was passed on 2/3/2006, and the petition was itself filed after expiry of more than 2 years. Date number से पता चलता मार्च के बाद ही फाइल हुआ. After expiry of more than 2 years, and ultimately the petition was withdrawn after some argument with the liberty to approach the competent authority in terms of the relevant provision of police manual. The authority has ultimately dismissed the memorial as time barred. It is not in dispute that the prescribed period for filing memorial is 6 months as per police manual. There is no explanation from the side of the petitioner as to why the memorial was not filed after the order of compulsory retirement dated 2/3/2006. Further, from the perusal of the records of this case, it is not in dispute from the side of the petitioner that earlier also 2 times the 4 punishments were inflicted upon the petitioner on account of overstay or being absconded from duty, twice minor punishment and twice major punishment. There is no explanation on the part of the petitioner as to why the petitioner did not perform his duty when he was asked to perform his duty on 4/1/2005 and absconded from the work. This court is of the view, considering the facts and circumstances of this case, this court finds no reason to interfere with the impugned action of the respondents under Article 226 of the Constitution of India. So far as the judgment passed by this court in WPS number 6652 of 2014 is concerned, the same was a case of overstay, and the perusal of Rule 843 the same was a case of overstay, and the reason for overstay was duly explained. However, in the present case, the petitioner has absconded himself from duty, and accordingly, the state judgment has not held the petitioner in any manner. Consequently, the present petition is survived.